there still is the safety mechanism, if you will, for judicial review of the comment that was made and how the court handled it. That really is the sum and substance of this. I'll be happy to answer any questions or go further, Mr. Chairman, or address anyone's
questions or comments. I'm looking at Mr. Reeves first to see if he has any.
It's nearly identical to the bill that this committee passed through that I also.
All right. Any,
if it passes today, we're going to help carry this.
Any distinctions that you want to point out that would for
the only distinction.
Go to the order.
Is on the.
Yeah.
The only difference between our two bills is, as Senator Kennedy described, in his bill, if the comment is on the guilt, then we kind of skip the analysis and it's automatically a new trial is issued. Gives a little bit more deference to the defendant in that really critical situation if the comment is about his guilt. I actually think that's a great idea. If I had thought of that, I would have included that in my bill. So,
thank you for those comments. Mr. Pack.
Logistical question. Contemporaneous objection, how would that work in the case that came out of Muskogee County? So what do you envision that the defense lawyer would do? Is it before trial, or before, I guess, the jury gets the case, or is it the judge makes a comment, then you stand up and say, Your Honor, can we have a sidebar?
It is precise. Excuse me. It's precisely that. It's a contemporaneous objection made as soon thereafter as the improper comment, and then it is made then outside or discussed outside the presence of the jury. So the judge is alerted to this issue, and then the judge can then make a decision as to how it needs to be handled, whether it warrants a mistrial or whether perhaps curative instructions are warranted.
The contemporaneous time period, how far does that extend? In cases of, I guess, in introduction of the case to the jury, the judge makes a comment like, this is a murder case that happened in Muskogee County. Can the defense lawyer object at the end of that and then be still contemporaneous? Or is it, here's an error, you have to raise it before next step? Logistically, I don't have any problem with it. It's just trying to understand when they need to do that.
Yes, sir. Representative Peck, I appreciate the question because this was actually an issue of some discussion in our committee. I think the contemporaneous would require the objection to be drawn to the court's attention as soon as practical, as in the normal court setting, as in if there's a question or answer that's improper, then counsel has to get on their feet and make the objection. There was some discussion as to whether or not perhaps there ought to be a larger period of time for that, but as we worked through that and realized that those that were trying to make an effort perhaps to help the accused in that event, that really wouldn't be helpful, because if you allowed to go beyond contemporaneous, then let's say you allowed an objection to be lodged the following day. Well, the problem is now you're reorienting the jury, and the judge is going to have to tell them and remind them what happened yesterday, and you're really doing that which the criminal defendant's attorney doesn't want, which is you're drawing more attention to what was made. So that the contemporaneous element of this, we thought and ultimately concluded, on our side at least, that was the most fair and well-balanced way to deal with it, and also allow the court to deal with it promptly.
Mr. Trammell.
Thank you, Mr. Chairman. Question I have is, I guess I might have a different take on what Representative Reeves had on line 14 about the judge expressing an opinion as to the guilt of the accused. I think in the version that we looked at and passed out of the committee, that language wasn't in there. And my question is, by including that, are we perhaps limiting the scope of reversible error to more on the spectrum towards a comment about the guilt of the accused? Do you understand what I'm asking?
I think I do, and I don't think it does, because the standard that's set out in the earlier portion of A, which is either it's improper for the judge to make a comment about whether a fact at issue has or has not been proved, or the guilt of the accused. The guilt of the accused portion is only handled differently in a procedural manner, in that procedurally, if it is a comment about the guilt of the accused, then it is then it's an automatic reversal on the appellate level.
A follow-up question, Mr. Chairman, if I might. But the premise of this bill is that there are some types of error, in this case commentary on venue, that we don't want to have an automatic reversal on. correct?
Yes, that's the venue is one example. Sure.
And so there are errors on a spectrum between a comment on venue and a comment on the defendant's guilt.
Yes.
And what I think the task is to try and achieve a balance where we're not getting an area that comes closer to that commentary on guilt, but maybe commentary on a crucial fact. That then you look at this language that says, well, we don't have to grant a new trial. We can give a curative instruction when in fact a curative instruction really misses the mark in that instance. Do you see what I'm saying?
I think I do, and if you're ranking by hierarchy of offense, then I would agree with you, and I think hopefully that's what this bill addresses, is that if it is a comment about the guilt or innocence of the accused, yes, that's on the upper end of the spectrum where the court doesn't have discretion, and they're going to get a new trial or there's going to be a mistrial.
And presently, the state of the law is the balance is if you make any commentary, then it's an automatic reversal.
Yes, Representative, and that's the problem. There is no, under the current statute, no analysis of, if you will, how offensive it is or how relevant or how material the comment was or how material the comment was about something before the court.
So
yes.
One last question, if I might, Mr. Chairman. Is there an example of an error other than venue that you can think of where a curative instruction might work as opposed to new trial?
If you had an example, if you had, for example, hypothetically, the state says that the witness was in a red dress and the defendant says the witness was in a blue dress, and the judge made a comment that I think it was a pink dress. Well, if the color of the dress were material to the case, then that is a comment on something material to the trial. But clearly saying he thought it was pink doesn't cut toward red or blue, or pick any color you want to between red and blue, which would be an example of where we would not want a judge's comment about something that, granted, is material to the case, but the comment didn't cut either way, wasn't prejudicial, didn't harm anybody, as in the venue example, where we ought not to make our judicial system retry or forced to try, go through a second trial, force the victims to go through that for a second time. So I think that would be an example.
Thank you, Mr. Chairman.
Mr. Coomer. All right. I see no further questions. There's no one signed up to speak on Senate Bill 99. Let me ask counsel if she has identified any issues, structural or otherwise.
I had a couple of questions that
Sure.
I didn't understand. One was on the language on lines 14 through 16 that we're saying that the judge, if the judge expresses opinion as to guilt, then you've got the appellate review. But then in lines 19 through 23, we have mistrial could be declared. It seems like if the judge is expressing an opinion as to the guilt of the accused, that the option of the mistrial should be in there.
It is. It is at line 15. Should any judge express an opinion as to the guilt of the accused, in the Supreme Court of the Court of Appeals or the trial court shall grant a new trial. And that's, under the current statute, the trial court does not have that authority to intervene at that point.
Granting a new trial and granting a mistrial are different, in my opinion, and from my reading of the law. So that's why I'm bringing up that issue. And then the other part of it is line 19 refers to subsection A. So it's all of A, whether it's the guilt of the accused or during any phase of the trial. And maybe y'all don't see any of these issues that I'm seeing, but I have some concerns. And then the last one is on line 20 read lines 24 through 26. You start with, you have to make a contemporaneous objection. And then line 26 says, such plain error may be considered on appeal even if it was not brought to the court's attention as provided in subsection B. And I think what that's saying is such plain error may be considered on appeal even if a contemporaneous objection was not made. And if that's the case, then it conflicts with the first clause of that subsection.
Senator, do you want to address that or talk it through?
Yes, Mr. Chairman. I'm trying to absorb what legislative.
I mean, did this come
counsel
over? Were these issues? Did these issues come up in committee on the Senate side?
No, and
it got changed on the floor of the Senate.
Oh, okay. Well, and in those applicable areas?
No. This did not get changed on the floor of the Senate.
There was an amendment.
There was an amendment that was defeated.
Okay.
Okay.
So this is the same that you dealt with when we were
Right.
the same bill that you saw when we dealt with it in Senate. I don't think the first lines 24 through 26 cause a conflict with the latter. I think 24 sets up that failure to make an objection in A precludes appellate review unless and it establishes the standard that if that violation is one of plain error that affects the substantial rights of the party, well then what happens if it is that? And that's what's addressed by the second grammatical sentence, which says if you in fact have such plain error, that still can be considered on appeal even if there was no objection brought to the court's attention. So I don't think I'm happy to receive any comments that legislative counsel, she's always very helpful, but I don't think we've got a problem there.
Let me ask Mr. Pack if he wants to weigh in on that or something else.
Something else. One thing about mistrial and then new trial. If it's a judicial error, is that automatically manifest injustice that you get that double jeopardy doesn't attach?
I'm sorry, what?
So in other words, if you get a new trial and the court declares a mistrial, I don't think it's automatically that you get to retry. It depends on many factors. And I think the court has to make a finding to supplant the double jeopardy clause. I'm wondering if that was debated. If the prosecutors say that's okay, then that's fine. But I'm afraid that if the judge makes a commentary in the middle when the jury's sworn in and taking testimony, and then the defense objects and they say, well, this the guilty or accused, and then you declare the mistrial, and then the prosecutor try to retry him again, and the defense is going to be double jeopardy, a clause attached.
I don't believe it's going to be an issue if the court was to make a mistake, the state didn't cause, and then one of the remedies was to grant a new trial. I don't think that's a problem. Really what we're doing is we're putting the trial court in the same position that the appellate court's in. And what this bill does different, like he said, makes crystal clear on the rules of commenting on the guilt of the accused. And so I understand the logic that Ms. Travis is talking about, but I also don't see it as a problem the way this bill's written.
Any further questions from members of the committee? Seeing none, I think what I'll do, Ms. Travis, let me look at you again and see, as the commentary that we've heard, allay your concerns from a structural standpoint or no?
I'm still confused. I'm sorry.
Okay, let's do this. If there is an issue, my sense is that it could be cured with a friendly amendment on the floor, and so in the interest of efficiency, what I'm going to do is ask the committee for a motion if it sees fit, and then what I think would be good is for Senator Kennedy to get with counsel and maybe with Mr. Speyhaus as well, and just walk through it again and get on the same page. And if we do need a curative amendment, we'll just go ahead and do that on the floor, and there won't be an issue. So with that, I see Ned's heads nodding, and so that's good. Motion by Senator Coomer of due pass of Senate Bill 99, LC 296527S. I'm sorry, Representative Coomer. Of due pass LC 296527S. Is there a second? Second by Mr. Strickland. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the gentleman's motion signify by saying aye. Opposed? The ayes have it. The motion is adopted. Thank you very much, Senator.
Thank you, Mr. Chairman. I thank the members of the committee for their time.
Have that conversation sooner rather than later, if you would, just to
Yes,
make
sir.
sure. Yes, sir.
I don't know if you heard there was a no.
Okay. Duly noted. I think I think the motion was still successful, though. Okay. All right. Let me call Senate Bill 154, Chairman Stone.
Thank you, Mr. Chairman, members of the committee. Senate Bill 154 is the what we call the body cam bill.
And we're just to make sure it's clear, we're dealing with the substitute LC 296588S. Is that right, Senator?
Let me make sure.
That's the only one we have in the file.
Is that the same as this?
No, that's a different bill.
154. We're working. I think we're working off LC 296588S.
That's correct.
Okay.
This is popularly known as the body cam bill. The main objective of this bill is to allow body cameras to be used by law enforcement during the lawful performance of their official duties. Currently, Georgia law does not allow body cameras to be used in areas where there is an expectation of privacy. An example would be when law enforcement is called to respond to a domestic disturbance dispute. That's in contrast to the common use of body cameras in public areas such as highway stops. But this is allows for those limited uses of body cameras, and it also in the process clarifies Georgia's definition of expectation of privacy as the location in which we're dealing. Now, there was a floor amendment to the bill that the intent of the floor amendment was to remove from disclosure recordings that law enforcement made. It was realized that this was overbroad, and that is why we have drafted the current substitute to make it clear that the only limitations to disclosure, exceptions from the Open Records Act, is in cases where there is recording made in an area where there's an expectation of privacy and no pending investigation. The exceptions to that are if you have a direct interest in what was recorded, and it follows in wording a similar exception that was passed 2 years ago for 911 recordings. So if you have a direct interest in what was recorded, say for example a domestic case, then you would have the right by filing an affidavit to access that information. So with that, I'll be happy to answer any questions the committee may have.
It's permissive in nature. There's no requirement.
Permissive.
Let me ask Mr. Spahos. Is this consistent with the language in 430 that was passed as part of 94?
Yes, sir. The amendment that starts at line 64 that's new, and quite frankly, a good policy. This would actually address some of the privacy concerns that were expressed in this committee when that bill came through, as far as all of those videos now being open records, regardless of whether or not there's a criminal case. This would just say, if these law enforcement officers, which are currently going into these private places under the lawful discharge and review, they can operate that camera. But if there is not going to be a criminal case, then that should be protected unless you can establish a reason to have that. But the exception provisions, yes, are straight out of 94.
Okay. Questions from members of the committee? Any questions for the author on Senate Bill 154? I see no questions. I'm looking to see if anybody signed up to speak. I don't think anyone has. Mr. Worthman, have you signed up for 134 or 154? 134. Okay. Okay, no, nothing on 154. With that, what's the pleasure of the committee? Ms. Ballinger moves due pass of Senate Bill 154 LC 296588S. Is there a second? Second by Ms. Cooper. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the lady's motion signify by saying aye. Aye. Opposed? The ayes have it, and the motion is adopted.
Thank you, Mr. Chairman.
Let's move right into Senate Bill 134.
Thank you, Mr. Chairman, members of the committee. Senate Bill 134 deals with the Georgia's anti-speed trap law. This law has been on the book for roughly 15 years, but it has had a significant exception. Let me first explain how the law works, and I will add, by way of background, Representative Tommy Coleman, I think, was the original author of the anti-speed trap legislation. The law currently operates to prevent speeding ticket revenues from being used for revenue purposes. That is, any speeding ticket collections that exceed 40% of a law enforcement agency's budget raises the presumption that the speeding ticket enforcement is for revenue purposes. The consequence of that is that a law enforcement agency in such a jurisdiction can lose its right to use radar detection devices. There was, however, an exception in the legislation that's been on the books for quite some time, and that accepted any tickets written in excess of 17 miles per hour above the speed limit. What's happened over the years, we've received anecdotal evidence that that tickets are being written just over the 17 mile per hour, and actually sort of in a window between 17 and 20, because after 20 miles per hour the super speeder law kicks in. There's been investigative reporting, more anecdotal evidence. So what this bill did originally was to simply exclude the exception, take away the exception of 17 miles per hour over. We've had considerable discussion with law enforcement, with the County Sheriff's Association, and also with the Police Chiefs Association, and that has resulted in a substitute that you have in front of you, which I believe, let me make sure I've got the right, is 391050S. Now, what's happened in the substitute, we've addressed issues. First of all, in Section 1, there's the issue of reporting. Law enforcement, local government reports to DCA annually on its budgets, but right now there's no mandate that they break out speeding ticket revenue. This simply directs that so that the law can be effectively implemented. The next section, Section 2, has been there have been changes incorporated to take into account the situation where rural jurisdictions have high volume traffic from the interstate system coming through their counties, And so we have an exception on lines 33 and 34 for that allow enforcement at 20 miles per hour over the established speed limit without reporting for speed trap purposes in those jurisdictions with 10 miles or more of interstate highway. That was a suggestion from the County Sheriff's Association, and we agree with them and have adopted that. Two other suggestions. These were from the police chiefs. One was that in police agencies, municipal agencies, that the threshold be reduced to 35%. They have to thank Frank Rotondo for recognizing that this is a problem and wanting to help clean up the issue. He also suggested that we include the related offense of driving too fast for conditions. That was apparently a frequently used violation to avoid having to ticket within the speed zones that would count towards the speed trap limitation. So those are the changes that you see before you, and I might add there is still the possibility that we'll see a floor amendment that would deal with the limitation on interstate highway mileage. That's something that we have not agreed with the come to an agreement with the Police Chiefs Association. Their view is that 10 miles or more is too much interstate highway and would effectively rule out most municipalities. But that is something that we may see if it passes the committee come in the form of floor substitute. That is probably to reduce that 10 or more miles to something between 2 or more miles and 10 or more miles. But there is a problem there. I'll have to tell the committee with small jurisdictions. I have one in one of the counties I represent, Oak Park, that has extended its municipality territory a mile north of its 300 population area of concentration to take in an interchange at I-16, and that they're one of the offenders. And so if we do reduce it from 10 miles per hour to something lower than that, it still needs to be significant enough so that we don't open the door for another loophole to our anti-speed trap law.
Thank you, Chairman Stone. Any questions for the Senator? Representative Hightower.
Just one, and you touched on it. What was the rationale making the counties and cities different, 35 and 40?
The counties did not ask for a reduction. The cities did. The police chiefs actually did, and that was a negotiated change. I would have no objection to it being uniform across the board, but I'm just explaining why it's not in this substitute.
Thank you, Senator Stone. Quick question. I know that oftentimes in the courtroom, a lot of multiple moving violations are altered in court and changed to 40-6-180, too fast for conditions, or basic rules violation is another name for it. Is there any way to account for if a failure to maintain lane is in court changed to too fast for condition? Is that gonna go in the category of this total?
The reason that is selected for a moving traffic violation that is counted towards the revenue limit is because it is specifically speed related. There's no way you can get to other innovative uses of pleading.
So it will. So will those add to the total number that we're using to get to 35 or 40%?
They would.
Okay.
And that was specifically recommended by the police chiefs that they cited. I won't mention the city, but they're a specific example of that.
Okay.
My question is about the super speeder law.
Yes.
And is the intention of the bill to include any of the revenue of the super speeder
No.
law toward that calculation?
It does not count towards the calculation. It's not considered a fine. It is a bill that is sent, I believe, from Department of Public Safety directly to the person. It's totally outside of the local enforcement, and it does not count.
Okay. And related question to that, though,
Yes.
the underlying ticket, so not the $200 fee that comes with the super speeder,
Would count,
would count.
except
And
with
you
the
want-
exception of the high volume areas that are covered by the interstate exception.
And I just ask as a policy question, the super speeder protection is to protect us from high-speed motorists.
That's right, and it's our belief that the state provisions are enough deterrent. They're pretty severe of their own to deal with that issue.
One more question, if I might, Mr. Chairman. The 20 miles per hour over exception, setting aside for a second which jurisdictions would be counted and which ones wouldn't, that doesn't cover all of. You can get a super speeder ticket and not necessarily be 20 miles over. Is that?
I'm not aware of that.
That's all I have, Mr. Chairman.
Okay.
See no other questions. Several people have signed up to speak on the bill. First, start off as Frank Rotundo from the Association of Chiefs of Police.
I don't mind sitting down next to him. Sure. Thank you. Thank you. Ladies and gentlemen, my name is Frank Vincent Rotundo. I'm the Executive Director of the Georgia Association of Chiefs of Police. First of all, I'm going to say that I enjoyed my conversations with Senator Stone. Most of the time we've been on target, and I too am offended if, in fact, that is the total objective of the law enforcement agency, to obtain monies for speeding. However, I see the need to certainly enforce speeding regulations. So therefore, the reduction of 35 miles per hour was certainly appropriate. To 35% was certainly appropriate. And I felt that other suggestions that were placed in this bill were appropriate suggestions. I do have some concern with respect to line 34 on this substitute, and as the senator brought it up, it had to do with the 10 miles of interstate jurisdiction. Although I certainly don't appreciate that small city, as Senator Stone mentioned, perhaps having a small portion of land and totally investing their police services into that small area, I do say that that 10-mile stretch is substantial. I can point out to the city of Savannah, Georgia, which is in that same general corridor, only has 8 miles, so therefore they would be eliminated. So I would like to see that reduce very substantially, if not that line eliminated completely. However, the concept of making sure that law enforcement is doing things for the right purpose is critical. And I too, as well as the members of my association, are concerned. However, saying that, I feel like I'm going back and forth. Last year we had 1,143 fatalities on the interstate. That's a lot of fatalities. attributed very clearly to those fatalities were 49 that were attributed directly to speed. That doesn't mean speed where they hit somebody in the rear, but to speed themselves. We must give law enforcement the liberty of doing their job. You set the speed standards. DOT worked with you in setting those standards based upon engineering evaluations. Law enforcement is merely following the order of the law that has been set forth by the senators and representatives and signed off by the government. There are a lot of other ways of determining speed as each city gets the money. Such as in one city may charge, if you're doing 12 overs over the limit, $350. Another city may charge $550. There's not any equity associated with that. So we're leaving it up to maybe the city governments to make those decisions. A possible something in the future you may wish to think about is standardization for first-time offense, first-time second offense. But this is a tool, sometimes perceived as being wrongfully used, sometimes wrongfully used, but very clearly it stops deaths. Nobody likes to get a speeding ticket. Nobody does. I think the very basic premise of this bill is very good. I would like to see it looked at and maybe massaged just a little bit more to make it palatable. There are a lot of other things that go into speeding in general. I could certainly answer any questions. I have brought another person, a practitioner here, who could say how many actual people speed through his community. It's a relatively small community. They happen to have 2.2 miles of interstate through them who would be adversely impacted by this bill, who does a very good job, falls very much below that 40% threshold, and would still fall below it with a 20% threshold placed on that, and that's Chief Joe Worthman. So, Mr. Chairman, if you would like to ask Chief Worthman to step forward, I would appreciate it.
Let me ask if the members have any questions for you, then I'd be happy to recognize Mr. Worthman. Any questions for Mr. Rotundo? Okay. Yes.
Mr. Chairman, may I just
Worthman,
conclude,
yeah.
and I'll step down,
Sure.
unless you want me to, and to thank Senator Stone, because legitimately he's doing it for what he believes to be right, and certainly does not want to have revenue based upon this.
Which reminds me, let me ask you one question.
Sure.
Why 35%? Where did you come up with that number?
Well, because we were looking for some alternative to Senator Stone's bill, was to get rid of completely. The original bill had anything that struck that language out, which was more than 17 wouldn't count. So with that in mind, I asked him if he would consider more than 20, and we would lower the percentage. About that percentage, that was invented in 1998 and 1999 by Terry Coleman. That's a high percentage. I suspect that most legitimate police agencies could easily lower it to 35% without impacting them at all and without impacting the quality of the speed enforcement that they do. So I too, you said something, Representative Hightower, about maybe equalization. Well, I did speak to Senator Stone about that, and his logic is certainly that there are a lot more interstate roads in the county, that the cities acquire sometimes the interstates by virtue of their boundaries, or they wish to extend their boundaries into that. The county boundaries are given and are set. So I understood why he did it, why that is a decision that he made jointly with the Sheriff's Association, but I certainly understand that we now have 3 different types of law enforcement units. State Patrol is under no standard associated with this speed regulation. They don't have to worry about 40% or anything else, or over 10 miles per hour before they could issue a ticket. We now have, if this bill goes through as it is, sheriffs on a different standard. We also have police on a different standard. So I respect your question.
Thank you.
Thank you.
Mr. Worthman.
Good afternoon. I want to thank Senator Stone for all his work on this. My name is Joe Worthman. I'm a police chief in Jefferson, Georgia, which is in Jackson County, just north of here on 85. Been been a law enforcement officer. I'm starting my 39th year in June, so I've been doing this for a while. Been the police chief there for approximately 8.5 years now, and it's a safe little town. I retired from South Florida, where the main crime was shootings, robbings, murders, and I come up to a nice, quiet town where traffic enforcement and the safety of our citizens on the streets is of main concern to our community. And we get complaints every once in a while from people say they're not speeding or they are. We have been investigated by the Georgia State Police. Our numbers were just under 1%, not near the 40%. This 35% wouldn't affect us one bit. I have numbers, and yeah, less than 1%. And we wrote last year approximately 2,700 speeding tickets. Sounds like a lot, but if you extrapolate that out into 12 months, and by day it comes to about 8 tickets a day, that's a little bit more than 1 per officer. We have a speed trailer that we got through a grant through the Governor's Office of Highway and Safety. And in just one location alone, I can give you the numbers. In a 3 or 4 day period, we probably have 200, 300, 400 cars 16 miles an hour or above the speed limit coming down our highways. That's just on the one four-lane highway that we have. When we have concerned citizens about speedings in their neighborhood or out in front of their locations or in front of the school, we put the trailer out there also, and you'd be amazed at how many people are speeding above 16 plus. My agency, we do not write a ticket. I know the media's here, but we give you 15 miles an hour, and we start writing tickets at 16, and usually about 1 in 5 get a warning, depending on their attitude and how things at time of day and night. The only zero tolerance we have is in a school safety zone. So just having said that, I appreciate Senator Stone, because I'm appalled that some agencies that would use this as a way for revenue, it makes us all look bad. I would venture to say that 98, 99% of our law enforcement agencies, state, local, and county, do the right thing, are trying to do the right thing, keep the streets safe for the motoring public. But those that are abusing it, I think, need to be singled out and handled. And if we can help Senator Stone make that work, we're going to do that.
Representative Hightower.
First, just commend you in running a very good operation. I mean, if this is less than 1%, that's very impressive. But with that, and you being an example of how to do this properly, is 35 still not relatively high? I mean, if you're below 1%, what can you give us a justification as to why some agencies would need it at 35% if you're at 1? And I know there's differences across the state, and you just know a little bit more about that.
And there's some smaller agencies have smaller budgets. So again, our speeding fine at 16 over is $157. So multiply that up. I have a $2 million budget. It's going to take a lot of speeding tickets to get there. Some smaller agencies, 4 or 5 man or person agencies, may only have a $300,000-400,000 budget. So speeding tickets will add up, get closer to that number.
Okay. And that's where I was wanting to get you to. I prosecute for a city that's very small. They have, I want to say, I think we have 2 full-time officers and 2 part-time officers. It's a very small city. We do all of our court and night court. We do trials and everything in about an hour and a half once a month. And that's what I was thinking the case may be. So thank you.
I think 35% is fair.
Representative Ballinger.
Thank you, Mr. Chairman. Do you not think that by limiting this, that would kind of ease off? Maybe, does law enforcement suffer any pressure from, city officials, hey, you'll need to start writing more tickets to generate more revenue? Does that occur? Does, I want y'all out getting people that beat their wives and that sort of thing and arresting child abusers. I don't really, I understand speed might be a concern to some, but I think there are just like bigger fish to fry. Do you not think that would help law enforcement to kind of refocus and kind of take some of the pressure off?
Well, I can't speak for other cities, although I just spoke at the GMA last week for the newly elected officials, and that was one of the questions I was asked. I'm blessed by having a mayor and a council that they're just happy that the crime rate is low, and we were nominated in, I think, the 6th safest city in Georgia.
Congratulations.
So, thank you. But they're just happy they leave me alone, let me do my job. I would hope that's all over this state, but I'm I would venture to say in reality that there are some agencies that are abused or some chiefs that are told you need to go out and write some tickets. Usually if they don't, they're usually on the unemployment line also.
Yeah.
That's not fair.
Mm-hmm.
But if you do it the right way, I mean, it's the 3 E's. DOT, the engineers of roadways, they come up with the speed. Then we try to educate the community, and we put speed limit signs out there. And if that doesn't work, then we have the last E is enforcement, and that's to slow people down.
Yeah. So you don't think something like this would help law enforcement? Would be a tool that if you were faced with the unfortunate situation of being pressured to possibly write more tickets, that this might provide a shield for them and help them?
It helps. It shows that we're willing to work to get things proper and to take care of the abusers.
Mm-hmm.
And again, I can't speak to other cities. I just can speak to what my city is, and the cities in Jackson County. I don't know of any chief that has come to me in the 8.5 years, and I also sit on the executive board.
Mm-hmm.
I don't see where they come to me and say, "Man, I have to go out and write more tickets because the mayor or the city manager or somebody has told me to do that." But in reality, that's probably happening, and those are the ones we need to take care of.
Mm-hmm. So you don't think this would help? Would it help or no, do you think?
You know, I don't know. I just appreciate Senator Stone. We're trying to address an issue that he has come up with, and we'll see where it goes.
Okay. All right. Thank you.
Chairman Setzler. He waves. Any other questions? Okay, thank you so much.
Thank you.
Rusi Patel with GMA.
Thank you, Mr. Chairman. Rushi Patel with GMA, and this is actually kind of an interesting bill for us. We testified over on the Senate side and did raise a couple of questions, and after speaking a couple times with Senator Stone and more with Frank Rotundo, we decided we would step back from the bill and actually go neutral. However, now with a substitute, kind of have to step back out, and line 34 is a big concern for municipalities. And I think the reason it's a concern is we're not talking about all law enforcement with this change on line 34, and we have to be clear about that. We're talking about city police departments. We're not talking about sheriffs. We're not talking about the state patrol. The only law enforcement that line 34 affects is city police departments. And it makes a presumption about city police departments that all city police departments are likely to be speed traps, instead of saying, you know, most law enforcement does a great job, and you know there are bad actors out there, and just like Mr. Rotundo and Senator Stone, we do not condone that. We think that's a really bad move, and it harms public safety when there's speed traps out there. But this language on line 34 makes a presumption of cities that don't have 10 miles of interstate, that they aren't responsible enough to use speed radar for those high speeds, and the high speeds are the dangerous ones. So we understand that Mr. Rotundo and Chairman Stone have been working on the other language. We're fine with the other language. This language, however, does create a major concern. And we understand it may be changing if this bill does move forward. We would actually prefer that language be taken out because it's strongly beneficial towards sheriffs and harms city police departments, and there are a lot of city police departments out there. And it does create an issue. And I'd be glad to take any questions.
Any questions for Mr. Patel? Would you live with 5 miles then?
I think one of the issues here is not just that cities that have interstate is there's 536 cities in the state, and if you get outside of Metro Atlanta, most of the cities are not on the interstate. They don't have any interstate at all. And what this would say is that if you do not have any interstate at all, or you have less than 10, so you have 1 to 10 or 0.1 to 10 or whatever you want to say, that you do not get to exempt that 20 mile an hour or 20 mile an hour from that 35 percentage. so basically, counties that have interstates would have that 10 miles of interstate, and the sheriffs in those jurisdictions would not mind. So I think it creates a different threshold for cities that do have interstate and don't have interstate as well.
Any other questions? Thank you.
Thank you.
We have finally Bob Dallas.
Thank you, Mr. Chairman, and ladies and gentlemen of the committee. My name is Bob Dallas, and I've been involved with highway safety matters before the two legislative bodies since 1990. I helped start a group called Safe Kids of Georgia and had the honor of serving under Governor Perdue as the Director of Highway Safety. And let me just begin by saying that I don't like speed traps. And I don't like speed traps because whenever there's revenue as an objective in highway safety, it takes away from the very most important thing, and that is saving lives on the roadway. So with that as a backdrop, it's important to recognize a few things in terms of what highway safety is. First and foremost, there are four things that are often focused on in highway safety because this is what generates the numbers of deaths in our state: distracted driving, impaired driving, occupant protection, and excessive speed. Those four things. And the remedies for that are looking at four things, and that is engineering, education, enforcement, and EMS. Those are the tools that are used to help reduce crash deaths in Georgia. During my tenure, we had as high as 1,705 deaths throughout the state of Georgia. About a third of those were speed-related. We've seen significant gains in Georgia in terms of reducing that, so that the Highway Safety Office today is looking at trying to get those under 1,000, which is tremendous. Now, the question is, what has driven that? I know the question of super speeder came up earlier. If you want to know who was involved in helping to create super speeder and encouraging this body to support that legislation and the governor sign it, that's me. Why did I do that? Because it was the most egregious speeds that resulted in so many of our crash deaths. Super speeder is part of the reason we've seen a lot of the reductions of crash deaths in this state. Now, having said that, what do we see in terms of what prevents speed traps? We have 10 miles an hour in order to use electronic means that you have to go over the speed limit if you're not state patrol. 500-foot sight distance, you have to have signage, you have to be GSP certified, and you can't collect a bunch of revenue from the lower speeds. So with that as a backdrop, there are a lot of tools in place that say jurisdictions do not become a speed trap because that sends the wrong signal. We care about highway safety, not the revenue when it comes to this. And that's the right message. So when I look at this legislation, and let me just say to Senator Stone, I do appreciate your coming forward. I'm sorry I did not talk to you earlier. Mr. Rotundo brought this to my attention Friday afternoon, hence I'm here today. My concern is that what we don't want is to send a signal to the public that speeding's okay. Let's not forget, the DOT has raised our speed limits throughout the state. Perhaps back home where each of you are from, I know throughout this region we've seen increase in speed limits for a lot of reasons. But that's based on data. They look at their data and they say, what can the roads do and what are the crashes associated with that so that we don't increase deaths as we increase our speeds. But the public, and let's say we all have been guilty of perhaps going to excessive speeds, sometimes doesn't realize the consequence of speed because we feel so safe. We know about the others because they tell us, you don't drink and drive, you don't drive and text, and you wear your safety belt. They get that message. But the speeding is, in my view, kind of the last frontier. So in that regard, I look at every single one of the many jurisdictions throughout the state as being able to step forward and help enforce a very important message: high speeds kill. And so with that, if segments of roadway, any segment, not 5 miles, not 1 mile, if any segment of interstate is not allowed to be patrolled for speed by a local jurisdiction, the concern I have is that segment combined with the segments next to it will not have the enforcement. That's not to say that the state patrollers are out there. They are, but they're not everywhere all the time. That's not to say the counties aren't out there, because they are out there, but they're not there even in their counties all the time. And when you look at the jurisdictions working with their highway safety office in developing a data-driven approach to effectuate safety, then the question is, does this take away from it or add to it? I think in bulk, the percentages, it could be 35%, it could be 30%. I don't think that's an issue. But when you take away the ability on a particular segment, it will be an issue. because a signal will be sent to the driving public. Hey, you know, the county may not do speed enforcement just because, like, I'm from DeKalb County. You have DeKalb County Police, but you don't have the sheriff's office working there. But you have cities, Doraville, Dunwoody, Sandy Springs, that are able to work 285, let's say. So those are the kinds of things that I'm concerned with, is that where we have crash corridors, such as that, and they can't enforce the speeds, then we've got a problem. So from my perspective, I would suggest to you that the other parts of the bill, perfectly fine in terms of addressing, this should not be about money. But when it comes to where, that really says to the public, in my view, it's okay to speed here. And I think that's the wrong message. Thank you, Mr. Chairman and members of the committee.
Any questions for Ms. Dallas? Thank you.
Thank you.
We have a late sign up, Mr. Norris for the Georgia Sheriff's Association. Like, Mr. Norris, if you could not repeat what the other people, it seems like at least one line has some concerns for a lot of folks.
I promise you I won't repeat any of that, Mr. Chairman. Very quickly, I'm Terry Norris. I'm Executive Director of the Georgia Sheriff's Association, here to support Senator Stone's bill and the amendments. I can tell you the 17-mile-an-hour threshold is because of a sheriff. This bill was passed some years ago. I don't recall exactly when, probably 15 or so. And it was passed because of the concern in this state about agencies working traffic, writing tickets for revenue. There is no question that was occurring, and it probably still occurs. So I think Chairman Coleman came up with the 40%. A sheriff came up with the 17%. 17 miles over. The reason that happened was the presumption for the sheriff was if I'm not writing a ticket until someone is 17 over, I'm not a speed trap. So that's how that conversation began. Now, I will disagree with my friend from GMA. This does affect some sheriffs with a 10-mile stretch because we've got sheriffs in which the interstates go through their counties with less than 10 miles. But the problem the sheriffs have seen for years is the fact that some cities will annex very small portions of the interstate just to sit on the interstate. Not Doraville, not some of the other ones, but it has become quite a problem in this state. And I commend you for let's talking about this, and maybe we can have further conversation. Mr. Chairman, we're not opposed to the cities, not opposed to cities working traffic, but in counties throughout this state, sheriffs repeatedly, not just on the interstate, sheriffs repeatedly get complaints from the community about the aggressive enforcement tactics in cities. So with that said, Mr. Chairman, I'll yield the floor.
Okay.
Thank you.
See no questions. Okay, what's the pleasure of the committee?
Move to pass.
That's good. Chairman Zessler?
Second.
Okay, he seconds. Any amendments?
Mr. Chairman.
Chairman Zessler.
Spoke to some other members of the committee, one of whom is not here. He had to leave to speak to another committee. I was going to try to create some uniformity here and make it 35% across the board. I could read the effect of that. I wanted to state that's the effect of my amendment. I would propose to do that by on line 29 through 30 by striking everything on line 29 from strike law enforcement agencies, and on line 30 through that, and just put in or, such that it would read 35% of a municipal or a county law enforcement agency's budget.
Okay. Did you get that, Mr. Travis? Okay. All right. Any discussion on Mr. Sessler's amendment?
And again, Mr. Chairman, if I think there's a sense of propriety that's been raised on both sides of this, I think we ought to be even Steven across the board.
Okay. Any objections to adopting the Sessler's amendment to lines 29 to 30? Sure, absolutely.
Do you have any departments that are going to get caught in that 5% if we move that from 20 to 35?
I'm not sure I can answer that with the other changes in the bill. We didn't have, I don't think we had but a couple of sheriffs that were even close to
So to the members of the agenda, Mr. Chairman, I just offered an amendment that would make 35% apply across the board. It would read 35% of municipal or county law enforcement agencies' budget.
Okay. All right. Those in favor of Setzler's amendment to lines 29 and 30 indicate by saying aye.
Aye.
Those opposed? It's adopted. Representative Trammell.
Thank you, Mr. Chairman. I would offer an amendment at line 34 to delete the words "in jurisdiction with 10 or more miles of interstate highway."
Okay. The amendment is to delete the underlying provision of line 34. Any discussion on this amendment? No? Okay. Senator Stone, are you okay with that, or?
Well, I'll be frank. I believe it should stay in, but the miles, in my view, it would be prudent to scale it back to 2, which was the request we received from the police chiefs.
Okay. All right. So procedural posture is Representative Trammell's amendment to delete the underlying provision of line 34. Those in favor of the amendment indicate by saying aye.
Aye.
Those opposed? No. Let's see a hand count. Those in favor, raise your hand. 6. Those opposed? The amendment passes.
Mr. Chairman, I offer another amendment at the appropriate time.
Okay. You're recognized. Go ahead.
Mr. Chairman, I would add after line 34 the following language, circulating it in writing, and any fines associated with a ticket that qualifies under OCGA section 40-6-189B as a, quote, super speeder ticket.
Senator. All right. Does everybody have a copy of the written amendment? The proposed amendment is to add the following language in line 34 after the word speed limit. And any fines associated with a ticket that qualifies under OCGA section 40-6-189B as a, quote, super speeder, unquote, ticket. Any discussion? Representative Setzler.
Just wanted to ask the author of the amendment what his intent was. Was it a speed threshold that would qualify as a super speeder even if it's not brought as a super speeder charge, or?
Well, the super speeder statute, as I understand it, is an 85 mile per hour ticket on the interstate and a 75 mile per hour ticket on a 2-lane highway. So you have a portion by setting the threshold at 20 miles per hour or over, where you have a gap where you can be a super speeder, but that
15. That
particular fine is going to count against the threshold for speed trap. That.
Yeah, so in essence, it's 15. If the amendment were adopted, it would be 15 on 70-mile-an-hour interstates, and it would be 20 everywhere else. Is that your intention?
Well, it's not 20. It's 70. It's 75. It may be 20, but obviously, if you're in a 45,
yeah.
Right.
Yeah.
The fee for super speeder doesn't go, but the statute doesn't make that delineation. The intent of this would be that the underlying ticket itself, not the fee, doesn't get counted against that total. So the fine that the locality collects doesn't get counted against their 35%.
Here's my concern with that, and I share it, and I appreciate the gentleman's candor. If you are a jurisdiction that has an interstate, we're in essence moving 17 down to 15 with this. I mean, if that would be if you have a 70-mile-an-hour interstate going through your jurisdiction, we're moving in a different direction. And to me, there's clarity in 20. My concern is that agencies can very easily pull someone over for doing 21 over and just charge them at 15 or 16. In essence, scoring an 8-run game with singles and doubles as opposed to any home runs, if you will. And I think I think staying at 20 provides clarity. So, I mean, I would just, in a very friendly way, perhaps oppose your amendment. But.
Mr. Whip.
Chairman Setzler, his concerns, I echo them. I think it's going to create some confusion. The way the super speeder is applied, it just, I think 20 miles per hour is clean and clear and just makes a lot more sense in the application of this statute.
I'll give Mr. Chairman the opportunity to comment.
Those last two comments, I think when you start making it more complicated, it's difficult to apply.
Okay. The procedural posture is the Trammell number 2 amendment that's handed out written. Those in favor of voting for the amendment indicate by saying aye. Those opposed? No. The amendment fails. Any other amendments? Okay, so the procedural posture now is there's a do-pass recommendation and a second to substitute the Senate Bill 134 as amended by this committee, LC 391050S. Those in favor of recommending do pass for the House substitute to Senate Bill substitute to 134 indicate by saying aye. Aye. Those opposed? Thank you. It passes. And Mr. Chairman, which House member would be carrying this bill?
Representative Golan.
Okay.
Was asked.
Well, he's volunteered now, Chairman Golan. And what about the other bill? Same. Okay. Thank you. All right. I'm going to call Senate Bill 130, Senator Thompson. Yeah. I'm sorry? Oh, sign up sheet. Okay, David. I do. You have an iPhone 6? Senator Thompson.
Thank you, Chairman. Ladies and gentlemen, I bring to you Senate Bill 130, reading from LC 213672. It's prohibiting the smoking in a car when a child is present. Committee, we had a planned video presentation supporting the information of the harmful effects today, but it seems the appropriations to upgrade our internet speed was evidently denied, so therefore I'll spare you the pain of trying to watch it buffer, and I'll try and be brief today in respect of your time. We're a much more educated society as to the harmful effects of smoking and secondhand smoke today. I believe everyone in the tobacco industry will agree that smoking is hazardous to your health. I'm not here today to restrict one's right to smoke, but rather to protect the children that are not afforded a choice for themselves. The American Lung Association states that secondhand smoke is responsible for over 150,000 lower respiratory infections each year, resulting in 10,000 hospitalizations. Children's Healthcare of Atlanta says that secondhand smoke exceeds the EPA limits significantly. The American Cancer Society says secondhand smoke has over 4,000 substances, of which 60 are known to cause cancer. Some of them are arsenic, chromium, pyrene, benzene, nitrosamines, aromatic amines, formaldehyde, and vinyl chlorine. Fox News recently had a test where as an adult lit a cigarette, cracked the window approximately 2 inches, then measured the pollutants in the air. Alarmingly enough, within 25 seconds, the air quality, or the pollutant level in the car, exceeded what we would deem as hazardous outside on an air quality index. 3 of the carcinogens listed above, arsenic, benzene, and vinyl chloride, are regulated in the United States as hazardous air pollutants. And naphthalene and aminobiphenol are both banned from dye manufacturing. The facts right now, 6 states currently have laws protecting children from smoking in a car, and there's current legislation currently in Florida, Connecticut, Pennsylvania, and Illinois. Some of the results of secondhand smoke in a confined area, which is what we're talking about in scope, are diseases such as asthma, chronic respiratory infections, ear infections, and cancer. Children consistently exposed to this are much more likely to also become addicted to cigarettes themselves. Fellow legislators, we're often afforded the privilege and responsibility to fight for those who do not have an opportunity or are unable to speak for themselves, i.e., the foster care system, our education we've taken up this year, autism bill, and recently the collaboration of the Senate and House on the cannabis bill. I realize many in the room may not understand what it's like to suffer from asthma, the feeling of helplessness just to take a breath, but myself and Representative Reeves both do. It's a scary feeling to not be able to take a breath. I do ask if you've ever heard the scream of a child in the night suffering from chronic ear infections or chest pains from pneumonia. As a parent, you would do anything you could to protect or eliminate this. Yet thousands of children suffer annually from these diseases when they're avoidable by not forcing them to breathe hazardous air in a car. I realize some in the room may say this is a nanny state, but I respectfully disagree. It should never be a parent's right to harm a child. The Constitution does not protect your rights to harm another. They stop with you. And it certainly stops short in the Declaration of one's right to life, liberty, and pursuit of happiness. A child's life is shortened by secondhand smoke. It's a proven fact. And therefore, their pursuit of happiness is also eliminated. The costs to our healthcare system in Georgia are alarming. Some of the numbers reported to me are an estimated $202 million in secondhand smoke and $4.9 million nationwide. And with that, I'll yield to you, Mr. Chairman.
Thank you, Senator. Any questions for the Senator? Representative Hightower.
Just a couple. And I see your passion about children. I have 2 small children, and I do not smoke around them, nor do I smoke myself, nor would I allow other people to smoke around them or in my car. But I would make that as a personal choice. I'm not worried so much about the nanny state that you're addressing as I am proper enforcement. You are very on point when saying that we need to do all that we can to protect children because they're forced in situations they can't prevent themselves being in.
Yes, sir.
100% agree with that. But my problem falls on a law like this when it comes to how its enforceability. I think that you may open a large window allowing law enforcement to make stops that on pure speculation. It's going to be hard. They're going to be making judgment calls across the board on how old the person is or if they're smoking or if they're not smoking. And it just may be tough for enforcement purposes. And that's my only caveat is that. And then it also says that it can't be charged with that alone. So if you do have a law enforcement officer that makes a stop on this and it's alone, that's the only thing they have. Based on this, it says this subsection, however, that a person shall not be charged with a violation of this subsection alone, but may be charged with violating this subsection in addition to any other traffic offense. So what we may be also doing is how enforceable it's going to be if we go towards allowing law enforcement to stop someone for this, that then possibly going to be promoted to find something else. Because if this is all they have, then they can't do anything with that. So then we're going to be essentially saying, okay, you can't give them a ticket for just this, and that may be that officer's passion. The same way it's your passion and mine to keep my children in a safe vehicle. But then they may be looking for something else to ticket them with. Does that make sense?
It does. And I've spoken to law enforcement about this before we brought this forward. They seem to be comfortable with this bill. It's not putting them in a situation where they're looking for this. There's plenty for them to do. We've just talked about testimony just a second ago. That's one of the reasons I wanted it secondary. I didn't want targeting just for that. There was a reason that we have it as a citation instead of a moving violation and so on. So we took all those things into account, sir.
Sure. Those are just some of the concerns, because what I don't want to see, I do want to see us protecting children, obviously. All right. I mean, and I hope that my questions here don't come across in the alternative, because everyone obviously knows that's an unwinnable battle. And myself with 2 children under 3, I'm going to fight for them anytime.
Right.
But my true concern is the enforceability aspect of it and the potential for abuse when they need some reason to pull someone over. Because there's a difference in law as a mistake to law and a mistake to fact when dealing with law enforcement and when they stop someone. And so this falls into something that could be very easily used as, well, it was a mistake of fact and not a mistake of law. A prime example would be, let's say you've fallen behind somebody and you see a male and female in a car and they're kind of slapping back and forth. Well, law enforcement officer potentially could stop them because he thinks there's a fight going on, pulls them over, and they're just playing, right?
Sure.
That could be a mistake of fact, and his stop would be fine because he did it in good faith, as opposed to a mistake of law where he pulled them over in a speed zone that's, the speed limit's 55, but he pulled them over for going 45 because he thought the speed limit was 45 miles an hour. You see what I'm saying? That's a mistake of law. Stop wouldn't necessarily be good. I'm just want us to be cognizant of another tool we may be able to give, because this is going to be very tough to enforce. It's going to require them to use a lot of speculation on age and other such factors.
Sure.
So those are just some of the concerns.
Yeah, I respect your opinion on it.
Yeah.
Thank you.
Thank you, Mr. Chairman. Senator Thompson, I think it's a good bill. I discussed this with you earlier. It's kind of common sense. Sometimes we have to codify common sense for those who can't look out for themselves. I have a couple questions that go along with what Representative Hightower was saying. Line 20, where you have private way. What was your intention with having this law also apply in a private setting on a private property? What was your intention with that?
Well, one of the things that came up is we were talking about whether it be the car moving or whether it was parked, right? And so the whole intention of this is, if this car is parked, let's just say in your driveway or something like that, and there was some other offense that was going on, again, secondary, that the law officer could approach under those conditions. That's all.
Okay. Well,
simply
going on to that point, my reading of line 23, and tell me if I'm wrong, I may be corrected by law enforcement in the room, but if you cannot charge on this code section alone, then can you not stop someone for this violation alone as well?
I would have to ask law enforcement about that. But the way it was written, we had a collaboration. I mean, there were some people that wanted it to be a primary. I said no. They wanted it to be a moving violation. I said no. So there was a collaboration of several people, from law enforcement to CHOA to others, to be able to write this and draft it in such a way to be able to accomplish this.
Right, and that may accomplish some of your concerns, Representative Hightower. If the truth is, if you can't charge somebody for this alone, you can't stop them alone for this as well. But thank you.
Yes, sir.
There's another code section that uses that specific phrase. I don't have it off the top of my head, but I know when I was looking at the bill, I did notice that those specific words were somewhere else.
Okay. Representative Ballinger.
Thank you, Senator. I wanted to kind of, talk to you, even though it's a secondary offense, and even though prosecution might be somewhat problematic because it is a secondary offense and you can't get that, it's not going to hinder the educational aspects of the bill, right? As far as raising awareness throughout the state and that sort of thing, correct?
No, it won't hinder it at all.
Okay, thank you.
Any other questions for, okay. Representative Reeves.
Thank you, Senator Thompson. I wanted to raise a point really in response to Representative Hightower's comments. I remember, I guess it was probably 6 or 7 years ago now, when the texting and driving bill passed. I was an assistant DA at the time, and one of the concerns amongst prosecutors and others is that it was going to serve as a pretextual reason for a stop. And I remember conscientiously, being aware of that and thinking through that and having those concerns. And I look back over my career since then, and I don't know. I'm not saying that there hasn't been that case made, but I know that I've never seen that case made, or I've never seen a stop that was based on speculation that somebody was texting, and that was the reason for the stop. And so that's just an analogy that I think of, similar to what you're describing here, as this serving as a pretext to the stop. I think that I look at this as in a public policy fashion the same way. Texting and driving is inherently dangerous, and everybody knows that. And I look at this much in this, and it's against the law, and it should be against the law because it is inherently dangerous. And smoking with a child in the car, I think everyone in this room would agree it's inherently dangerous. And so that's just if it makes you any more comfortable, I think that's a very similar type law that has recently been passed, where I know that I personally haven't seen the abuse of that obviously in our world and the kind of cases that we deal with in our careers, it's the first thing that pops in our mind, but I've never seen that happen with texting. So.
Senator Thompson, on line 25, you say that this code section, a violation of this code section shall be a misdemeanor punishable by a fine. Are you intending to, in a misdemeanor, you can actually put somebody in jail for a year? Is that your intent, only to make it a fine, or are you trying to just make it a regular misdemeanor crime?
Strictly a fine.
Okay. All right.
Yeah, we have no desire to take children away. We have no desire to put undue responsibilities on the jails by locking someone up.
Okay. And this is brought up by this counsel, and it's a good point. Did you intend this to be a moving violation so that someone would get points?
No. No, sir.
Okay, then probably need to add some language to exclude that.
Okay.
Okay. Any other questions for Senator Thompson? No? Okay, I have several people have signed up to speak. Gordon Draves.
Hello, Chairman and Committee. My name is Gordon Draves. I'm president of Georgians Against Smoking Pollution and the co-chair for the Tobacco Action Team of the Live Healthy DeKalb group. We thank Senator Thompson for introducing this bill, which will be the Smoke-Free Cars for Children Act, and I hope it gets passed this year. The situation is that exposing children to tobacco smoke is a danger, and I think that we should do as much as we can to get people to not do that. And sometimes it takes laws to give the impetus on this very dangerous habit for or producing secondhand smoke, which is very dangerous for children and such. Why should we be concerned about it? Tobacco smoke has many, many carcinogens and other toxins, and it contributes to various other illnesses. Asthma is one. Tobacco smoke can trigger asthma and make the attacks more often and more severe. The situation is that it is a big deal for the child who is affected by this pollution. It's the number one reason why children go to the hospital. It is also the number one reason why, or from chronic conditions, for children to miss school. So the situation is that, it is a very, increases our cost, medical care cost, and also absenteeism from school. It also contributes to inner ear infections. And this is another way children are impacted educationally if they can't hear as well. And it can affect the hearing and also even lead to deafness. What is the number one operation for children? Putting tubes in their ears because of inner ear infections. And tobacco smoke contributes to those. So this is an important reason for this bill. 2 illnesses I talked about affected by tobacco smoke, 2 illnesses that can limit the number of days of school attendance, 2 illnesses that can result in hospital stays. And there are others that Senator Thompson mentioned. Please pass this bill to reduce exposure to tobacco smoke. 7 states and Puerto Rico have already done this, and several others worked on it this year, including New Mexico. The Senate did pass it there. But Georgia would have been the first one if it had passed in 2003. Representative Paul Smith of Rome introduced it, and then in 2004 it did pass the House of Representatives, and in the Senate was combined with the Smoke-Free Air Act of 2004. It passed the Senate, so in essence it did pass both chambers. But it didn't pass the House in its new form. And then both chambers passed Senator Thomas's Smoke-Free Air Act of 2005, which will celebrate its 10th anniversary on July 1st. But it didn't address the issue of children in cars with tobacco smoke. Today's bill will help reduce children's illnesses and hospitalizations. Please pass along this bill for House debate. And on education and enforcement, yes, it does need to be enforced, but it is also an educational tool. Thank you. You have any questions?
Okay. Representative Gravely.
Thank you, Mr. Chairman. Do we have a? You said 7 states.
Yes.
Do you have a list? Which states have already implemented bills
Arkansas
like this?
was first. That was back in, I think, 2006. And it was like age 8 or something, and then they promoted that up to age 14, under age 14. California, age 18, and also, let's see, one of the other states. I didn't print out my thing.
You had Arkansas, California.
Arkansas was the first. Louisiana followed. Puerto Rico. And I can't read that.
If I may.
Yes, sir, Senator.
Yes. You've got Arkansas, California, Louisiana, Maine, Oregon, Utah, Vermont, and Puerto Rico. Currently, Florida, Connecticut, Pennsylvania, Illinois are in legislation.
Thank you.
So some of them have it as a primary offense, and some of them, or most of them, have it as a secondary offense.
One more, Mr. Chairman, if I may. In the what is the average age of these 8 states and some of those considering legislation? What is the age threshold?
Vermont is the lowest at under age 8, and California, and I think it's Oregon, age 18.
18. So you wouldn't be able to do it
under age 18. Sorry.
So 17 years old.
Yes.
Thank you, Mr. Chairman.
Any other questions for Mr. Draves? Chairman Sessler.
Thank you. Thank you very much.
Oh, you have a question, Mr. Draves.
Yeah. Yes, sir. There may be nobody in this legislature that is more personally opposed to smoking. I'm just, my kids can amen that. I just go on and on and on and on and on and on about what a dumb thing it is to smoke. I mean, I believe it is. I could go on and on. I don't have to speak to that. My concern is, we think about $100 fines. We think about it's kind of a simple thing. But everything we do that's a criminal statute, this isn't a civil penalty, this is a criminal statute, is enforced with the power of the police state, the power to. No, do I believe we're going to go out and detain people for this and have lock people up for this? I don't see people going to jail for 12 months for this. My concern is philosophically, why a criminal statute to enforce this?
Well, I guess I just would say that sometimes we do need laws to prohibit things for the safety of other people. This is a health matter that would contribute to the health of children, and I think that is a very noble effort, and that we should do that. And sometimes enforcement and fines and such get involved. I hope that this will be an educational thing where most parents will obey it, and we won't have the fines at all.
I asked the question, have there been any states that have enforced this with a civil penalty?
Well, I think all of these are just fines.
Okay. No, the bill as it's crafted, again, my senator, dear friend, is the sponsor here, so it's this is certainly nothing personal. I'm just asking the substantive question. You know, we like to think about we're just sending a message or trying to encourage people, but I mean, every criminal statute at the end of the day is enforced with guns, jails. I mean, you have the police power enforcing this. Is that the appropriate way to enforce this? And people ask that question, and they kind of grimace. Well, guns and jails, that sounds extreme. What are you talking about? But every criminal statute is enforced by the police powers, and enforced with the ability to detain people. Messages aside, is there not if we're equally committed to you to effectuate the end state, is there not a better mechanism to do that through a civil penalty or something that's not a crime that's enforceable with, again, the fine may be limited, but that's not enforceable by jail time?
The jail time and such I don't think is necessary myself, but I think the fine would be a good deterrent to many people.
Any other questions? Thank you, Mr. Draves.
Thank you very much.
Next we have Kate Haygood.
Chairman, members of the committee, my name is Kate Haygood, and I'm with Children's Healthcare of Atlanta. In an effort to respect the committee's time, I will be very brief. Children's is supportive of this measure. We believe it's a great step to protect kids. One area I just want to briefly touch on is asthma. That is the #1 reason for admissions to children's healthcare hospitals. Smoke is the most common trigger for asthma. It makes it worse, more frequent, end up spending more time in the emergency department, missing more school. Smoke also makes a child twice as likely to develop asthma when exposed in a vehicle. I'm happy to answer any questions, but I know that y'all have a full plate today. So.
Okay. Any questions from Ms. Haygood? Thank you.
Thanks.
Let's see. Here we are. Marcy Thrash.
Chairman and members of the committee, I'm not going to repeat what's already been said from the health aspect. I do sit here representing the American Heart Association, but I'd like to take a little bit different tactic and share with you some of the other ways that we protect people from cigarettes, smoke, and secondhand smoke, and that is where we don't allow smoking in workplaces. We have the Clean Indoor Air Act. We have college campuses banned smoking and even e-cigarette use, all tobacco use last year this time. We have 101 out of our school districts as of this week having tobacco-free policies on campus. Nearly 90% of Georgia's smokers start using tobacco before the age of 18, so limiting exposure to that is incredibly important. Our Medicaid claims alone on tobacco-related illness are $567 million. I'm not sure exactly how many of those are with children, but I can get that information. And on February 25th of this year, we had our 25th anniversary for smoke-free airlines, and that was brought up because of secondhand smoke from flight attendants and them contracting illnesses as a result. So we are limiting secondhand smoke in a lot of areas, and so we're just supportive of this measure to also limit this for children. So I'd be happy to take any questions.
Any questions for Ms. Thrash? Thank you. And lastly, we have David DeLugas.
Thank you, Mr. Chairman. My name is David DeLugas. I'm a trial attorney in Georgia and have been for 30 years. I have an 8-year-old child. I abhor smoking, but that's not why I'm here to testify. He and I will walk across the street to avoid a smoker standing on the sidewalk. This bill either should not be passed or it should be redone so as to avoid for all persons, children, adults, to avoid secondhand smoke anywhere at all times. But it doesn't do that. So let's talk about some of the ramifications. Representative Setzler brings up the real issue is how that's going to be used.
Has anybody considered the impact on Child Protective Services? You're now making it a crime to smoke with a child in the car. Does Child Protective Services now get a report of abuse of a child, neglect of a child, harm of a child? Are we diverting resources? Unless we're going to write something in here that says this shall not or not be a basis for Child Protective Services to investigate or to accelerate or to enhance an investigation into a report of abuse or neglect of a child. Are we doing that? Have you considered the impact on funding if that were to take place? By the way, a pediatrician told me once as I was presenting a family law case in Cobb County that secondhand smoke in the material in the car, even if there's no active smoker, is extraordinarily dangerous. So why are we not banning smoking in a car altogether if a child or an adult, because maybe the adult is elderly and frail? Let's go as far as we need to go or don't go there at all. Because again, you please consider the impact of unintended consequences. The testimony you just heard, and I'm not a doctor, I'm sure is accurate, but does the person who just got stopped, who's a smoker, then immediately go home, enter their home with their child, and out of all the nerves of how am I going to pay this $100 bill, $100 fine that I'm facing, how am I going to get off of work without losing my job, to go to court because I don't have a credit card to pay for it online, I'm going to lose my job, I'm going to lose a day at work, I'm going to lose $100, which is 14 hours at minimum wage. They're going to start lighting up cigarettes, and that child's going to be in the home. Are we now going in their home? And by the way, if we were to do that and make it illegal to smoke, I could support that a lot more than I can support this piecemeal notion of we're actually doing something fantastic for children under the age of 15, but the 16-year-old, they can suffer. Not that law enforcement really can know from driving by or stopping somebody in their driveway of their house. How is the driveway of the house not an extension of the home? I mean, are we inviting some litigation on that issue? So again, let me be clear. Smoking is a bad thing. It hurts everybody. But it doesn't just hurt people that are 15 and younger. It doesn't just hurt them if there's an active smoker. Are we going to have issues with the smoker puts out a cigarette as their child approaches the car? The child enters the car, they drive off, and now they're pulled over. Who's going to believe whom? The smoker says, I put the cigarette out. Yes, but there was smoke and you could smell it in the car. Law enforcement writes the ticket. Who are we punishing? Sure, everybody in this room presumably can pay that $100 fine just like you can pay a $100 speeding ticket and move on. But who's the person that can't pay this? And again, I suggest that maybe the biggest impact that you haven't considered is what are we going to do with Child Protective Services and tell them? Because you pass this, you've just told Child Protective Services, a parent who smokes in the car with a child, and maybe it's true, maybe that is a form of abuse and maybe we need to investigate, but I would submit that with finite resources we probably have bigger child abusers and neglectors than we do those parents who are smoking in a car, because we haven't made it illegal for them to smoke in their house or smoke in their private business in the back room or somewhere else. So I'd ask you as again, voting against this bill isn't an indication that you're not for children's safety. It's more of an indication that you want to think it through and recognize that while smoking may be a trigger for asthma attacks, the asthma attacks and the triggers for them are everywhere. I mean, they're going to be outside somewhere just on the corner down the street because you can't avoid people that smoke just about, although I and my son make every effort to do so. So I would implore this committee to give grave thought before passing it through just because it's for the children. That should not be enough of a rallying cry without considering other ramifications.
Do you have a question for Mr. Douglas?
Yes, sir.
Okay.
How would you, if this committee were to contemplate a civil penalty versus a misdemeanor as a litigator, how would you see that play out differently? Certainly the threshold for proof would be lower. It'd be easier perhaps to bring a penalty against someone than a criminal beyond a reasonable doubt standard. How would you see that play out in practice, or would that be unworkable in your mind?
I think it'd be unworkable because really what we're saying is, by the way, has anybody conferred with anybody proponent of the bill, conferred with those about how do we change behaviors? Because in reality, we don't really change a whole lot of people speeding by giving them speeding tickets. We should recognize that. The person who's addicted to smoking, and I smoked up until 1981, and a bleeding ulcer was what the doctor got me to quit smoking on, and I haven't smoked since then. So I'm the reform smoker. I think smoking is atrocious. I believe anybody can quit, but can you really imagine that this is going to be effective? So if the goal is to protect children, let's find out, somebody do the research, how do you get people to actually stop doing this rather than simply putting another burden on people who for some reason can't? And again, we're not protecting them elsewhere. But Representative, my bigger concern is what's the message to CPS? Are we telling them that is the ticked off neighbor or the ex-spouse going to be calling CPS and go, psst, the mother's smoking in the car when our 14-year-old's in the car? And now CPS going to be under a directive to go investigate? After all, it's now a crime in Georgia. Maybe not, if amended, it would say misdemeanor with no prison term permitted. But still, the person who's doing this is getting off work, losing a job maybe, paying a fine they can't afford. So,
Mr. Chairman, I asked the question because even if there's no jail time, you still have, if it's the commission of a misdemeanor, that still is kind of a predicate towards moving towards CPS taking action. It could be used in a custody case.
It's going to be used in a custody case. I'm a family law attorney. I assure you, somebody who got that ticket, now we're going to bring a modification of custody on the basis of this alone, and then we're going to ask our family trial court to determine whether this is a sufficient change in circumstances to warrant a modification. And depending on the individual judge, if the judge smokes, probably not. If the judge doesn't smoke, possibly.
Okay.
I mean, again, safety of children paramount, harming others, but don't set any age for anyone to smoke in a car with any other occupant in the car, or to allow someone in it if they've smoked in the last 24 hours. Something. Okay. Please give more thought to it.
Senator Thompson, given the concerns with some of the language that probably needs to be worked on here, what I suggest is that we hold off acting on this bill until maybe Wednesday, give enough time to get some of the work of the language to try to get it to address some of the concerns of the members. Okay? Thank you. I see Chairman Tippins over there. And so that would be House Bill 185. Senate Bill 185.
Thank you, Mr. Chairman, members of the committee. I appreciate your time. I'll try to be brief. I would imagine y'all have heard and reheard this conversation probably as much as you want to. I want to give a little background. Many of you may ask, why am I asking for a hearing in committee when in fact House Bill 1 has been heard in the Senate House and Human Services Committee, and Senate Bill 185 was rolled into it. Those of you who are students of history probably have studied World War II, and there was a novel written about it, and it was The Bridge Too Far. I think, quite frankly, that House Bill 1 was a bridge too far. It went too far to try to address a very real problem. I didn't introduce Senate Bill 185 until after House Bill 1 was passed in the House, and I did it quite frankly because I've got concerns as we look at very emotional issues. We have to be mindful of our role as stewards of public policy. I'm not going to go through the bill specifically, but I will tell you what the bill does. It authorizes the expansion of the existing program that the state has through the University System Board of Regents to enter into contracts for clinical trials for the study of cannabidiol oil, and to determine the extent to which it's effective in the treatment of seizures. My concern in House Bill 1, and the reason I believe that Senate Bill 185 is a much more measured approach, is number one, the physicians in Senate Bill 2 have to be board-certified neurologists or specialists in the field for which they're practicing medicine, and not just any physician who has a physician's license to prescribe this. I'm concerned about the medications that are used and permitted to be used under House Bill 1. I believe it provides for 20 ounces of cannabidiol oil, of which 5% is THC by weight. And this means that in 20 ounces, at 5%, you have 1 ounce of pure THC. But there's no guarantee of the purity or no guarantee of the content of these drugs. I'm also concerned about the diagnosis, and this goes back to the physicians being certified as being able to diagnose very puzzling symptoms at times, and not just an attending physician. We've been through the battles in the years past to do away with the pill mills in the state of Georgia. I do not want this to be a segue to go back to the drug houses or the oil houses for cannabidiol oil. When the bill makes a provision for the containers for the drug to be carried in, and it says it will be in a container marking the content. That's all well and good. But how do we know that it's 5% THC and not 55% THC? Law enforcement today has no way to test that and prove it at any given time, and especially in the field. This bill, as it was passed, House Bill 1, was very, very perplexing to law enforcement. The Georgia Sheriff's Association, the Georgia Association of Chiefs of Police, the Georgia Council of Prosecuting Attorneys all expressed concern about it. The district attorney from Gwinnett County came and testified in the Senate about his concern about how far this bill would take us down the path of legalization of marijuana in the state of Georgia in an uncontrolled setting. More than that, the people that we look to and rely on for our health care needs in the United States, the medical community, the American Academy of Neurologists have come out against a bill like this until there are clinical trials conducted to determine the efficacy of it in treatment of different diagnoses, but also to see if there are any negative effects. That's the role that clinical trials play. Not just is it good in a particular area, but are there any harmful side effects? The American Academy of Neurologists have stated the long-term brain damage that comes from this drug, and it's not been proven that it's safe. They're very concerned. The Georgia Association of Pharmacists have expressed the same concern. I'm not going to wear you out going through long reasons why we ought to do that. But one of the biggest issues that I have with the bill is by definition, as defined by federal law, House Bill 1, and the possession of cannabidiol oil is illegal according to federal law. It's true. The Department of Justice has issued a memorandum of understanding, or a memorandum saying that they would not prosecute these cases. But by definition of federal law, it's illegal. I think it's poor public policy when we pass laws knowing that they're illegal as determined by federal law. I believe Senate Bill 185, because it is a clinical trial, and it's conducted under the auspices of FDA-approved guidelines, and the medication used is certified by a laboratory and not just any provider. It provides a safe route. It may be just a little bit slower route. It was intended to be a little bit slower route. We need to move cautiously down this road. We'll find ourselves in a medical and in a legal quagmire if we don't. That's the reason I've introduced the bill. I'm sensitive to the needs of people. I've got 6 grandchildren. I can only imagine how I'd feel if one of them had seizure disorders, and I'd want the very best medical treatment. But I would not want a medication administered to them that 10 years from now I could look back and say, man, we really have paid the price for moving to a medication that has not been through clinical trials if they had long-term brain injuries. Had a neurologist tell me, said the problem with THC is it rewires the brain. It causes schizophrenia. It causes other diagnoses that we don't like to see in children and we deal with every day in our school districts. I want to urge you to consider this bill. I believe the bill's good medicine. I believe the bill's good law. Even if you try to do the right thing, but you do it the wrong way, it's a mistake. I want to encourage you to look at this bill. I don't have a personal stake in it. I don't have anybody paying me to be here. But I believe that the laws that we pass today ought to be laws that we can live with and hold our heads up down the road and say, I voted for that and I was proud of voting for it. I believe a cautious approach to this is a much wiser approach. I won't take up any more of your time. I know the hour's late. I'll be glad to answer any questions you may have.
Chairman Golick.
Thank you, Mr. Chairman. Senator, I support your bill. I support your bill as a standalone. I support your bill as part of the package with House Bill 1, which is now traveling. I think if one thing, and you expressed your concerns on the medical piece, and I don't disagree with you. And that's exactly why, if you take a close look at House Bill 1, that really, when it comes right down to it, we don't make the decisions on who may have the access to the oil. That's ultimately, if you look closely at House Bill 1, unless the Senate's changed it, which I don't think it has, in this particular provision, it really is a medical decision. Now, I spoke with a good number of neurologists as well as we were formulating the substitute here, and there's trepidation. There's concern about just stepping into that realm overall, let alone getting into the specifics of it. And so we took a giant step back and made the policy decision of, look, this is really all about positioning. It's about timing. As the science develops through clinical trials, both here and in other states, maybe federally, I don't know, the question will be, as science advances on it, and as the clinical trials move forward, and as determinations are made from a scientific standpoint, that yes, the oil may be useful for A, B, C, D, E conditions, depending on the patient, depending on the circumstances. The facts of each one of those are very different. So because patient A, who may have one condition, and patient B, who has the exact same condition, let's even say they may even be male, 48 years old, whatever it may be, that particular patient, those two particular patients may not necessarily both, for whatever reason, be good candidates for it. Who makes that decision? It's the doctor. And we vested a lot of power into the medical board to determine what the protocols are going to be. Not just some physician, like a mail order physician, but the actual treating physician. And we give the medical board rule and regulation authority to go ahead and set out the rules on that. Why? Because 236 people in this building are not positioned properly to do that, and we understand that. So when I hear the slippery slope argument, without wanting to go ahead and debate House Bill 1 yet again, which I don't think anybody wants to do, I think it really is important from your comments to clarify and set the record straight that we vest a lot of the authority, if not all of it, really into the hands of a medical professional. And I've tried to tell this to families who I've spoken with as this debate has gone on. This is not this is not a free ticket at all. This comes, there are going to be people who think that they're going to get this medication, if it even can be called medication at this point, who will not. And the decision is going to be made with a doctor. And as medicine progresses and moves forward, or not, they're the ones who are going to make the decision. So I think really the answer is it's to be determined. It really is to be determined. What House Bill 1 ultimately does, with your, inclusive of your amendment, what it ultimately does, it just positions potential patients to potentially receive the oil if their doctor, their actual treating physician, as per the rules and regs of the medical board, potentially makes the determination of, yes, this potentially will work for you. That's a lot of potentialities, and that is very much on purpose. Why? Because it is new ground. And the tenor of your presentation just now was, it's scary new ground. We're not scared of it, but it is new ground, and therefore we step carefully on it. So I see the marriage of your bill and House Bill 1 as being a good marriage. Ultimately, science will prevail. Medicine will make the decisions it's going to make. It may be maybe 5 years before the medical board says, no, we're going to go ahead and do this, or yes, we're going to do this, or no, we're not. They have to come out with rules and regs at a certain point in time, certainly, but it may not be the rules and regs that people want. But ultimately, they're the ones that are going to decide, and that is as it should be. On the federal piece, very quickly, I don't believe, and I think you'll find the prevailing tenor in the House is that it's not a question of whether we should act or not act pursuant to federal law. There are times and issues in this building over the course of time that I've learned in my experience that at some point you have to go ahead and lead the federal government. And we've done that before on issues, and I think issues while you've been here, as a matter of fact. because we lead on those issues as opposed to waiting for the federal government to lead, which is a futile task sometimes depending on the issue, people's lives and their quality of life is at stake. And so we make, again, the threshold policy decision. Do we wait on the federal government, an act of Congress, according to the expression, or do we go ahead and push them along? The fact that 20-something states have acted in some manner, we believe is pushing them along. And I understand the Justice Department and what's been funded and what's not been funded in terms of DEA enforcement. We don't rely to our detriment on that. But the bottom line is, by virtue of our acting, it doesn't mean that we're saying to Citizen X here in Georgia, yes, please go ahead and violate federal law. It doesn't say the opposite either. It simply expresses our policy vision, nothing more, nothing less. That's where we're coming from on it. I support your bill as a standalone. If for some reason something occurs with House Bill 1, for Representative Peake's sake and his sanity, I hope it does not. But if it should, we certainly, I think we'll certainly more than favor Senate Bill 185. I appreciate your listening to me on that, but I think your comments were a little strong, and that's okay, and I respect that, and I respect you. But it's important to understand where we were coming from and why, and really, more to the point, about really who's the gatekeeper on this thing. The gatekeeper is the physician, and that is as it should be. Thank you, Mr. Chairman.
Representative Gravely.
Thank you, Mr. Chairman, and a longtime friend from Cobb County. I appreciate as well your passion for this. As the co-sponsor of HB 1, I think everybody in this building knows we have fought diligently and time and again, asked for that input. And I'll tell you, I was extremely grateful to Senator Unterman for the committee she ran last Thursday, and very much support the merging of SB 185 and House Bill 1 so that we have both components that will address this issue in our state together in one piece of legislation. I would express caution from this standpoint of SB 185 being a standalone bill, simply because of the conflict we could have with the code section and the work that has been done. It was my understanding, having attended that committee last Thursday, that all parties that had invested time had worked on this particular measure, and I won't speak for any other groups or organizations, had come to a consensus on the merging of SB 185 with the clinical trials into HB 1, some of the concerns that were addressed. Matter of fact, I think we even, I think one extra diagnosis had been removed. I would urge some caution with the committee in looking at SB 185 separately as opposed to the package I think that was passed out of the Senate committee last Thursday. Very much support the clinical trials, very much want to get the needed research, but also would like to see that move along in the package of HB 1, I think, which will be on the Senate floor tomorrow, if I'm not mistaken. But that would be my remarks on that, is urging the committee to have caution when we have a vehicle moving forward tomorrow.
If I may respond to that, and I certainly understand the House's concern, and I appreciate their diligence. I will say this: I do believe that the clinical trials are the quickest way to lead to a validated and a verifiable rescheduling of the drugs, and I'm not opposed to that at all. I think if the drugs were rescheduled where they could be prescribed and distributed under normal pharmaceutical channels, we'd be much better off. One thing that did bother me that I meant to cover earlier, and with your graciousness, I'll cover this. I asked the GBI. The one thing that concerned me along the way was I've heard people say, well, it's the cannabidiol that really brings the effectiveness in the treatment, and it's not the THC. But yet the THC was up considerably from what the original bill was last year. And I called GBI and told them, I said, my dilemma is this: I need a conversion equivalent of the psychoactive ingredient equivalent to what we're talking about in terms of joints of marijuana, of street-grade marijuana. And I said, given a normal street-grade marijuana with whatever THC that it may be, to get the same psychoactive effect, how many joints of marijuana are you talking about? And they sent back and they said, with one marijuana joint typically weighing 1 gram, being whatever percent it is THC, they gave a range. They said it would take from 60 to 400 marijuana joints to reach the equivalent level of 1 ounce of THC. I think we need to ponder that as we move forward. That's an awful lot of psychoactive drugs that we're putting on our streets.
Representative Sisler.
Thank you, Mr. Chairman. To the author of the bill, I thank you for 185. And I don't say that I say that for very specific reasons. I had a gentleman come up to me at church yesterday, had a little potluck, and he said, "I'd really like to thank you for passing that bill that that provides that oil to those kids who are having seizures." And I said, "Well, I appreciate you saying that. I think there is a need to provide oil for kids that are having seizures, but do you realize what the House passed was dramatically different than that?" He said, "Well, I had no idea of that." I said, when we were debating the oil for kids having seizures, we were talking about 0.3% THC, cannabidiol oil limited to children under the age of 18 for seizure conditions. What passed out, I described to him what passed out of the House, 5.0% THC by weight, not 17 but 8 conditions, and he was stunned by that. He said, "Wow, I had no idea about that." He said the public outcry and this groundswell of support we've seen over the last 2 years, the righteous groundswell of support, from my vantage point, is what SB 185 provides, Senator Tippins, and I appreciate that. I think the people have heard the need for SB 185. I strongly question the need for HB 1. It's passed as part of the process of moving it forward. I supported it in this body. But this is what I've heard of the last 2 years the people of Georgia want. This is what I think the people of Georgia think they're getting, which is a cannabidiol oil, low 0.3% THC to deal with these conditions in the context you've set forth. I think you've hit the bullseye, Senator Tippins. I appreciate you for it.
We don't have any other speakers. What's the pleasure of the committee on Senate Bill 185?
Pass.
So we have a do-pass motion for Senate Bill 185, LC 371973S. Do I hear a second? Second by Representative Setzler. Any amendments? Representative Gravely.
Yes, sir. If, a friendly amendment, quite frankly, just to mirror what the Senate committee did, and if you'd like to take a moment, we could discuss that or whatnot. But I'd like to amend SB 185 with the Senate substitute that was produced after last Thursday's Senate committee hearing of HB 1.
Do you have a copy of that?
Yes, sir. I've got one for each member of the committee.
Chairman Golick.
I appreciate where Representative Gravely's coming from. I don't think that Senate Bill 185, let me put it this way, I think House Bill 1 is moving on its own volition regardless of what happens here. I know that, and I just wanted to, Mr. Chairman, ask the author, I assume the author would not be supportive of having his bill substituted in that manner, correct?
Well, obviously, it's to the discretion of the committee to act in any way you so choose. I would not ask for that. I would not really favor that. And one reason I came today is nobody knows really what's going to happen to HB 1 tomorrow, and I would like to have 185 as a viable alternative.
Well, out of respect to Senator Tippins, I think it would be, I think House Bill 1 has a life of its own, and my sense of it is that it's moving deliberately in the process. I would not, and I understand where the gentleman's coming from, and on pure substance, I'm with him. But I know that the author, wants to have his bill judged on its own without that, and I think it presents a choice ultimately to the General Assembly. And as much as I support HB 1, as it's assumedly going to pass out of the Senate and come on over for an agreement, I would ask the gentleman respectfully, if he would, to withdraw his amendment, simply so the author can go ahead and have his bill as a standalone considered. It can move to rules where it can be considered further. And then we'll take a look at how House Bill 1 is traveling, and that affords us options, frankly, as it goes along. I just want to be respectful to Chairman Tippins, and I know Representative Gravely does too, and I don't want to suggest otherwise. But I think for our purposes here, and out of respect to the author, I'd ask him to withdraw the amendment with all due respect, so that he can have his bill considered on its own as a standalone. I just make that request.
Mr. Chairman, proper time. I'll defer to my chairman, but also out of respect to the senator and our long-standing family relationship, I will withdraw the amendment.
So Representative Gravely has withdrawn his amendment, so there are no other amendments I see offered. So the position is there's a due pass recommendation for Senate Bill 185 LC 37-1973. Those in favor indicate by saying aye. Aye. Those opposed? No. Okay, so hand vote. Okay, those in favor of a due pass recommendation for Senate Bill 185 indicate by raising your hand. 1, 2, 3. 1, 2, 3, 4, 5. Those opposed? It's a tie. 5-5. It does not pass.
Thank you, gentlemen and ladies. I'm sorry.
Could we, is there a way in the spirit of keeping the senator's bill viable as an alternative, is there a way for the committee to reconsider its motion, leave the bill in committee not dead but as a living bill? Just a question to the chairman.
Absolutely.
I think what we could do, given the fact, unless we're going to have a vote for reconsideration, which we could do right now, and then see what the vote would be there, then have another vote on passage. If the result did not change, there could be there could be an additional motion. Just because a bill does not get a due pass recommendation does not mean that it's dead. What the committee could do in that respect then is to then, if it wasn't successful after a motion to reconsider, then there could be a motion of no recommendation, which I sense would pass given the tie vote nature that we've had, unless it passes after reconsideration. Of course, from my standpoint, just as a matter of courtesy to the senator, I'd like to see his bill pass as a standalone, as one of the biggest champions of HB1. I think it's I don't see it being a threat. I don't mean that in any negative way to House Bill 1's traveling at this point. But I do think it, given the fact that it is a significant portion of what is now HB1, I think it warrants a positive recommendation from the committee. If there's a motion, Mr. Chairman, I'm going to go ahead and move to reconsider, ask the committee to reconsider its failure to give Senate Bill 185 a due pass recommendation. And just for members of the committee, a reconsideration vote does not mean it's a final due pass vote. It's simply reconsideration. And I'll make that motion right now.
Motion and seconded. The procedural posture is we're reconsidering voting on Senate Bill 185. Those in favor of reconsidering our vote on Senate Bill 185, raise your hand. Those opposed? Okay, so it passes. The motion passes. So we are reconsidering Senate Bill 185. Would you like to have a vote now?
Yes. Parliamentary inquiry. I don't know, and it's up to the respective chairs. I don't know if you want to consider it today and vote it, or if there needs to be further discussions. I made that parliamentary inquiry earlier to allow the bill to be alive in the committee. Certainly, the chair's discretion there. Is it something the chair would contemplate considering at a later date, or is it something the chair wants to act on now?
Senator,
what
would you prefer?
I'll leave it to your discretion. I'll be fine with it leaving it in the committee. If HB1 falters and you have a bill you can operate with.
Okay. Do you have a motion?
I just was, I don't know if there's a motion to postpone consideration. We would just adjourn the committee hearing if that's the chair's pleasure.
Okay. Then we'll take no action on it at this time then.
Thank you for your kind consideration.
Okay. Senator Williams, you have the last two bills.
I will try to make this as quick and painless as possible. I appreciate your guys' patience and hanging out. Which bill would you like to take up first?
Let's take it in order. You have 160.
Alrighty. Just like to make one clarification first on a lot of the explanations of Senate Bill 160. I've seen it referred to as a bill that changes the consequences for underage drinking, and that is not correct. It does not change the consequences whatsoever. Typically, basically what it does, it kind of changes the default in how underage drinking is to be treated. Currently, there's a lot of kids out there that are saying they're being arrested just for the possession of alcohol. What we'd like to do is kind of change that so that if an officer sees an individual under the age of 21, they will cite them first. That will be the first line of I guess, the officer is supposed to take. Now, if there's any reason where they may be causing harm to themselves or somebody else, intoxicated or whatnot, then the officer obviously will be able to arrest. But that's simply what it does. I would like to make an amendment, though, to the bill. There's been some discussion with the prosecutors, and they're in agreement with the essence of the bill, and there's just been some discussion about the way the bill is written. If you look on line 16, it basically says, any person accused of violating any provision of Code Section 3-3-23. That code section also refers to somebody who might be selling or providing alcohol to somebody under the age of 21. Myself and several others believe that the way the bill is written, it still allows them to arrest for those instances, but just out of spirit of compromise, we'd like to change that to any person accused of violating provision A, 2, 3, or 5 in Code Section 3-3-23, which specifically addresses those that are under the age of 21, possession or fake ID. And with that, I will accept any questions.
Any questions for Senator Williams? Could you repeat that? Would you propose to change in line 16?
17-4-23, any person accused of violating, then scratch any, provision A, 2, 3, or 5 of Code Section 3-3-23. And then a very similar change will need to take place on line 31 as well. It would be cause to believe that a person accused of violating provision A, 2, 3, or 5 of Code Section 3-3-23.
So, would it be parentheses small a?
Yes.
Okay, then parentheses 2, comma, then parentheses 3, or parentheses 5.
Yes, sir. Yes, Mr. Chairman.
All right. And then I have, okay, we'll start with Representative Hightower.
If you look at line 14 and 15, you strike out may and add shall. But then if we look at, I believe, let me find it again now that I've lost it. On line 33, it said the arresting officer may effect a custodial arrest of such person. Why are we using shall on the front and may on the back? Again, this is if the person is a danger to himself or herself. But I understand, but if they're a danger to himself or others, then they may effectuate an arrest. They don't have to, they may. But on the front page, where they're not endangering anybody else, it says you shall. Sure, may I defer to? Sure. Yeah. And I know the difference in the arrest that you're doing.
The concept, honestly, being the second provision you refer to at the shall or may, honestly gives that arresting officer some discretion. In other words, I have been in a situation like that where
I like that may.
Yeah, I know. I felt like you would be supportive of that. the officer could very well be faced with an individual that meets this definition, but the parent may also have shown up. And you may at that point be able to issue a citation and release to the parent. The reason, what we're trying to get to here, and this is how we got pulled into this bill, was to make sure that police officers weren't left stranded with an individual that they've been told by this body to issue a citation to,
Sure.
but it's just not safe to leave them. And that's why we've done this. This second provision gives them that authority to exercise that discretion. They can issue a ticket, or if they got something else safe to do with this kid, give him the ticket and send them to the parent.
Then jump back to 14 and 15. Why would we not leave that as may?
Well, that's a policy statement. That's the whole kind of underlying concept of this, we didn't come in supporting or opposed to that, is that we are by default on simple possessions when the kid's not intoxicated by that second definition down there, then we're not going to arrest those children. Those young adults. We're going to issue them a citation and deal with this later in court. And that's the kind of premise behind it. So if you leave it at may, then you're really not changing the status quo.
No, we're saying you may arrest, and you're saying shall arrest. There's a difference there because he's making a difference on the actual arrest that's happening.
Beginning, they're saying shall arrest by issuance of citation. That's a defined term, and that means to effectuate an arrest, give them a citation, and release them. That's where that term, that concept of issuance of a citation, arrest by issuance of a citation, is referred to in code, and that is an arrest other than a custodial arrest that requires them to be turned over to jail.
I understand. But by changing that to may arrest by issuance of a citation, you can't use that?
You can. It's a policy.
Well, you see what I'm saying? I understand.
Yeah.
I understand the difference in the type of arrest. My only problem is that, let's say you have an officer who has a kid who has alcohol in their possession. Example that I may have is, because for me, I didn't even know this was a law. You learn a lot once you go to law school and then do prosecution, do defense work. My aunt was getting married when I was younger. I was 18, and my dad told me, he said, look, there's a keg at our house. You need to go pick it up and bring it to the reception. I wasn't drinking. Parents didn't let me drink. I didn't drink till I was 21. But I was transporting that. No one in our family really knew there was an issue. I just had a truck, and my dad needed to get it. So I went, picked it up at our house, and brought it to my aunt's reception. This, if we change the may to shall, we're giving them very limited discretion on giving me a citation. Where if we had may, the officer could listen to what I'm telling him. My dad could show up, and the officer could go, okay, yeah, this is not, I see, I may here instead of shall.
Well, nothing in this code section will require the beginning of a criminal proceeding at all. Okay. I mean, this is if there's been a decision by a police officer to either make an arrest or issue a citation. Police officers got authority all day long not to make that arrest.
Sure.
And you got a provision under 3-3-23 that says even if you're underage and you're being directed by your parent, you can have alcohol. So all that would come into play. This is if you've decided to initiate criminal charges. But
I think if it's by your parent, though, it has to be at their house.
It does.
So my scenario wouldn't quite work, but I got you.
You would probably have started out with consent, then you would have been outside of it. So I agree. I mean, but I don't know how you're going to deal with that. That's a law enforcement discretion issue about even bringing the charge.
That was kind of that was all I was saying there.
And also one of the reasons, actually one of the primary reasons having the shall in there is a lot of time. Actually, in my discussions with several chiefs of police, especially at some of these large college universities, their only time they are arresting is if there is some other type of offense going on, if they're a danger or intoxicated or something like that. But then the kids, they'll go back to their parents and say, well, the police officers, they were targeting us, they didn't like me or something like that, and they're able to basically demean the value of that citation, that arrest. And by doing this, it takes away that argument from the kid saying, well, Mom and Dad, I really wasn't doing anything else. Well, if you were arrested, son, you were, because the law says you shall get a ticket unless you're doing something else, then you're going to be arrested. So it also helps to bring conversation to underage drinking as opposed to just sweeping it under the rug because the cops are picking on me.
I just had a question.
Yeah.
Okay. All right. Representative Reeves. Oh, Strickland, sorry.
I'm going to again follow up on what Representative Hightower was saying. I have the same question. We talked about this in my office as well. I understand what you're doing by making sure you're taking away the summons and accusation, so you're taking away the arrest there. But if we said may arrest by issuance of a citation,
would that still not be an option? Could you, the only way, and that's for you, Chuck, if we said may, would it still give that officer discretion to just do a citation and not to have the option of arresting, or does it need to be shall?
It would give the discretion, but would also then kind of erase the undermining reason for this, which is to take away those people that are being arrested the excuse for they were just picking on me.
Okay, so the intention with the bill is to make sure a citation is always issued in these cases.
Yes, every time you see somebody underage, they're going to be cited. There's something else, they're going to be arrested. Again, to help conversation with the parents and those involved.
Okay.
Okay.
All right. Any other comments? All right, nobody has signed up to speak. So what's the pleasure of the committee? Representative Strickland.
I'll move to pass Senate Bill 160, LC 410471.
Okay. Second by Representative Gravely. Any amendments?
Yeah, as amended.
Okay. Well, we'll do that in a second.
Okay.
All right. All right, so the author, I'll offer the amendment. In line 16, erasing the words any under violating any provisions, or eliminate the word any, and after the word provision, add in there parentheses small a, close parentheses, open parentheses, number 2, close parentheses, comma, open parentheses 3, close parentheses, or open parentheses 5, close parentheses. And so the sections shall read, that line should read 17-4-23, comma, any person accused of violating provision A, 2, comma, 3, or 5 of code section 3-3-23, period.
Yes.
Is that right?
That's correct.
And we'll make the exact same amendment, similar amendment in lines 31. Eliminating the word any that's located between violating and provision, and then adding the same subsection A, 2, 3, or 5.
Yes.
All right. Any objections to the amendment? Hearing none is adopted. So we have a due pass recommendation for Senate Bill 160 as amended by the House Committee. Those in favor of due pass recommendation indicate by saying aye. Aye. Those opposed? Hearing none. Okay, it's passed. Who will be carrying this bill in the House?
Senator Strickland.
Okay, Senator Strickland.
I'm sorry, Representative Strickland. Representative Strickland, my apologies.
Or demoted, I guess. Okay, so the last bill we have is House Bill 195. We don't, Nikki leaves. You should be quick on that. All right.
All right.
We have very few minutes. You're about to lose quorum.
Okay,
so
we'll make this quick as well.
Brevity is a virtue.
Basically, Section 1 increases the annual fee for continuing education from $125 to $250. Section 2 requires a bench warrant for any principal that does not show up for a court when they're assigned to. And then Section 3, we would like to make a quick amendment to Section 3, but basically this adds or removes from the United States its terminology that the federal government is moving towards in place of deported, and then making it so that they can present the documentation mail, email, or hand-delivered. The amendment is on line 69. We would like to unscratch the word official, then scratch comma, state or local government. 69. Am I? I have the wrong
67. Which?
I'm sorry, 67. I'm sorry,
Okay,
I had the wrong version of the bill. My apologies. 67.
So you're working off of SB 195 /FA/2?
Yes. Yeah.
Okay.
Now I am.
So the amendment that you're proposing is
Line 67.
Yeah.
Unscratch official.
Okay.
Scratch comma state.
Mhm.
Leave or scratch local government. So starting from line 66, it would read official documentation from a federal official or agency shall be considered proof.
Okay. Got it.
And that's it.
Any questions for the author? None. I have a couple people wanting to speak on the bill. We have Charles. Let me call him anyhow. Charles Shaw.
Yeah, in the interest of brevity, the Georgia Association of Special Bondsmen, legislative chairperson, we support the bill. Basically, I will entertain any questions if any of the committee members have. I own a bonding business in Fulton, Gwinnett, Bartow, Clayton County. Served in law enforcement for 7 years. I have a Juris Doctorate degree from the University of Louisville. This bill was written in the educational portion
has not been raised in 11 years. We want to improve the content and the import of the education, and by doing that, we feel that this is a very reasonable increase. The necessity for the warrant here basically just codifies de facto practice at this time, where if there is an aberration, we feel it's only equitable that if the bond's to be forfeited, that there's a mutual obligation between the government and the surety to get the defendant back before the court. And the agreed language with Mr. Spejos that you just addressed in the amendment was to just make more seamlessly and make more uniform the documentation received from Department of Homeland Security or ICE in being relieved of the bond in the event of a deportation or removal.
Okay.
We support the bill and appreciate very much your time here and consideration.
Any questions from Mr. Shaw? Raymond Krebs.
No.
Okay. All right. So that's. No, I don't. No, we don't. Okay. So, what's the pleasure of the committee? Okay. Move to pass by Representative Gravely.
Second.
Seconded by Representative Strickland. Any amendments? Okay. We have one amendment proposed by the author. Line 67, unstriking the word official, and then striking the words state, local government. So it should read, official or agency shall be considered proof of the principal's deportation or removal. Any discussion on the amendment? Those in favor of the amendment indicate by saying aye.
Aye.
Those opposed? It's adopted. So we have due pass SB 195 as amended by the House Subcommittee, House Committee on judiNon032315EDITED. Those in favor of due pass recommendation indicate by saying aye. Aye. Those opposed? Congratulations. And I think this
Thank
is
you.
Representative Harrell, right? Representative Harrell?
Yes, sir.
Okay.
Thank you, sir.
Thank you. We're adjourned.